Good afternoon, everyone. Good afternoon and welcome to the Vacketta-DLA Piper Lecture on the role of government and the law, which for more than a decade has brought some of the nation's most distinguished leaders to the University of Illinois to share their experience and insight into our nation's politics and world affairs. This lecture series is made possible through the generosity of College of Law alumnus Carl Vacketta, class of 1965, and his longtime law firm, DLA Piper, one of the world's largest and most prestigious firms. Carl, unfortunately, cannot join us today, but we're thankful for his generosity and steadfast dedication to the College of Law and for the support of his former law firm. I extend a virtual welcome to Carl and to those joining us via live stream at DLA Piper offices around the continent. I understand, having spoken to her as I walked in, that one of our speaker's former colleagues from the Massachusetts Supreme Court, Justice Elspeth Seifer, is here with us today. Justice Seifer. Frankly, we get too many of these Massachusetts folks in here. I'm worrying about a takeover. You have your own state. You're welcome to stay for a while, but please go home afterwards. Justice Seifer has recently moved to Champaign to be closer to family, and we welcome her not only to today's lecture, but to our community. Welcome. Yes. Today, we are pleased to welcome Scott Kafker, Associate Justice of the Massachusetts Supreme Judicial Court, to the college as our distinguished speaker. As we were chatting earlier, the Massachusetts Supreme Judicial Court, the oldest judicial body in the United States, right? So, Illinois is good too. Whereas Justice O'Brien from the Illinois Supreme Court is also one of our special guests here today. We still love our home state Supreme Court. Yes. So after graduating from Amherst College and then the University of Chicago Law School, where he served on the Law Review, Justice Kafker began his legal career as a clerk to Justice Charles L. Levin of the Michigan Supreme Court, followed by a clerkship with Judge Mark L. Wolf of the United States District Court for the District of Massachusetts. Justice Kafker then worked briefly in private practice at a Boston law firm before taking an opportunity to go back to public service, first as Deputy Chief Legal Counsel to Governor William F. Weld, and then as Chief Legal Counsel for the Massachusetts Port Authority. He has remained in the public sector ever since and spent 16 years on the Massachusetts Appeals Court, including 2 years as Chief Justice from 2015 to 2017. Kafker was appointed to the Supreme Judicial Court by Governor Charlie D. Baker on August 21st, 2017, and remains there to this day. His dedication to public service goes beyond his work as a jurist. He has taught a course at Boston College Law School, authored numerous book reviews and articles, served as president and dean of the Flashner Judicial Institute, and is a member of the American Law Institute. In today's talk, Justice Kafker will outline how law students interested in public service and law professors doing scholarly work in common law subjects and constitutional law ought to give a second look to state courts, state governments, and state constitutions, which have often been considered as only second best protections of our individual rights. Again, please join me in welcoming our speaker today, Justice Scott Kafker.
Thank you for those kind remarks, Dean Sharp. In his last will and testament, William Shakespeare famously, or perhaps infamously, left his long-suffering wife only one bequest, his second-best bed. Shakespeare scholars, legal historians, and property law professors have spilled a lot of ink trying to make sense of what second best means in this context. Was it derogatory and mean-spirited, or was it merely descriptive of the difference between the fancy, decorative bed in the guest bedroom that was more ceremonial and the bed used every day for the married couple, and thus an intimate and integral part of their lives? When compared to the federal courts and the federal Constitution, state courts and state constitutions and the protections they provide for our individual rights and liberty are also often described as second best. Like Shakespeare's bed, I think we need to give this second best description a second look, as Dean Sharp just said. I would like to do this from a very personal perspective, drawing on my experiences in state government and also my time teaching and writing about state constitutional law. So before I put on my rose-colored glasses about living life on the state side, I'd like to take you back to my final year of law school at the University of Chicago. And I'm taking trial practice with two state trial court judges, the same court that Judge Walker, I don't know if she's still here, hi Judge Walker, in Cook County. They were fabulous professors, and I loved the class, but I was a little taken back when they were one of only 2 or 3 judges who were not indicted in the Cook County Greylord scandal. For me, I also became sort of familiar with dishonesty at the highest levels of state government. When I was the Deputy Chief Legal Counsel to Governor Weld and Chief Legal Counsel for the Massachusetts Port Authority, I spent a lot of time negotiating and legislation with the 3 speakers of the House of Representatives of Massachusetts. I was really impressed by how terrific they did their jobs. They passed these bills that we really needed for both places. But I was also surprised when all 3 were indicted, although not fortunately for anything I worked on with them. But anyway, as one of my mentors, who is a federal judge and former public corruption prosecutor, reminds me, you need to be careful. I don't know how many law students are here. I look like I've done better with the faculty. But if you're a law student, make sure you work for someone honest, either in state or municipal government or in any other job, because it's probably the most important decision you're going to make out there. Anyway, I digress. Like I suspect some of you, when I was in law school, I was determined to clerk for a federal judge. That was my first and only choice. I sent all my applications to federal circuit court judges around the country and flew all over the place. Now, again, I'm old, so this is before email and Zoom, so I'm flying around. Each time the judges go to me, where are your recommendations? I go, oh, they're in the mail. More accurately, they were in the mailroom in Chicago because the postal workers were all out on strike. So I got no jobs, which was a bit of a bummer because I really wanted to clerk. So luckily, my professors, Jeff Stone and Cass Sunstein, got on the phone and called Charles Levin, who was a judge on the Michigan Supreme Court, and got me a job. And it was absolutely fabulous. Not only was he brilliant, but he was incredibly affable. He was also a bit strange. We'd have to go to his house. He liked to work in his pajamas. So every night, and he liked to work late too, so every night we'd show up to work on our opinions. He'd be in his pajamas, and we'd stay there, and then we'd drink scotch, and then we'd have to drive home. Now Justice Levin, cousin was Sonder Levin, and his other cousin was Carl Levin, so driving home, I was working for a senator, a congressman, and a state Supreme Court justice. Driving home was perhaps the scariest part of the job after all that scotch. But again, I digress. Most importantly, I want to emphasize that the issues addressed by the state highest court are novel and fascinating, and I found much more interesting than the issues I worked on when I clerked a second time for a federal district court. And I know some of you clerked federal district court judges, so I'm not saying anything bad there. But again, in my humble opinion, clerking on a state Supreme Court is really the best clerkship. And I've confirmed this with my law clerks. I don't know if Justice O'Brien's confirmed, but they tell me that it was more interesting even though they went and worked for the First Circuit or a federal DMAS. But again, it's not because I was easy to please, or as they say, I can be a difficult, grumpy old man. But again, the issues were so interesting that made up for it. But again, I cannot emphasize enough the significance of the work of state courts at all levels. Statistically, they do the vast majority of the judging in this country. State courts are the workhorses driving the judicial system. For example, in 2023, which is the last year we have complete statistics, there were 395,000 new federal cases. There were 67 million new state court cases that same year. Now, even if you cut out the small traffic and debt collection cases, there were 40 million new state court cases in 2023. That's 100 times the number of new federal cases. And lots of the small cases that state courts decide can also reflect major societal problems. Professor Lawless's book on debt's grip, I'm sure, makes that point. We've got a major societal problem with debt collection and debt, and it plays out in the state courts. If you're like me and you love the common law and common law reasoning, state court is also the best place to be because that is where it is practiced and decided every day. And if you like to write, and everyone in this room, I'm sure, imagines himself to be a legal literati, there's no better place to be on a court to write about the law. Unlike the federal courts, which have these multi-step processes and tests they have to do each time, I won't belabor that, Dean Sharp, but the writing often comes off a little clunky in those federal, supplements and federal reporters. I think it's easier to write about the common law well than it is to do federal statutory writing. And when I was on the Intermediate Court of Appeals, I often felt like each case, even the little ones, contained its own fascinating short story, and I got to be the short story writer I wanted to be. I'm sure Judge Walker has this experience as well. I'll give you one example. So one month, I'm assigned an odd case in which an overflowing toilet sadly resulted in the electrocution of someone who was attaching the hose to water the flowers in the house. This presented an unusual question of foreseeability and causation. And it actually, I got to interpret Paul's graph, which I never understood in law school. And my case ended up in the tort casebook. I don't know if you use it here. Is it Epstein's case? I can't remember. There's one, yeah. Yeah, Epstein taught torts at Chicago when I was there too. But I had the other tort professor. Apparently Epstein spent the whole time, he created a volcano and he imagined a volcano and all the liability that came out of that. And he never worked from any of the cases in the casebook. But so on state Supreme Courts in particular, we get to address the most interesting questions of common law. I've been asked to write opinions defining, for example, the duties owed by a university to students who've expressed suicidal thoughts, to professors or college administrators. I've also considered whether tenured professors' salaries may be lowered, an issue near and dear to many of you in this room, I'm sure. For that opinion, I came out on the good guy's side. I relied heavily on Professor Matthew Finken's scholarship. In another case, the court I had to sit on had to determine the legal obligations of a university museum to the descendants of slaves whose ancestors' images in the form of daguerreotypes were taken against their will by a famous racist Harvard scientist. My former colleague and close friend, Justice Seifer, who's moved to Champaign, is here today, as we know, and she disagreed vehemently with me on how I resolved that case. So I am not going to answer. If you put your hand up, I am not calling on you unless you agree to not ask questions about Lanier versus Harvard. Promise? All right. My court has also been on the cutting edge of contract law. For example, when you take an Uber home tonight or any day after this homecoming when you're going to these parties, and God forbid the driver gets into an accident and you're badly hurt, have you contracted away your rights to sue Uber when you hit the I agree tab 2 years ago when they sent you an update and you didn't read beyond the first page of the screen? Check out our decisions in Cowders versus Uber and Good versus Uber. In Good versus Uber, and I love that case, right? Good versus Uber. I dissented from my colleague, Justice Dalila Wentland-Arguez, who is a graduate of this institution, not the law school, but she has an engineering degree from here. So on major common law cases, justices on the state's courts, particularly our state Supreme Courts, are of course engaged in a nationwide dialogue with each other, informing each other's analysis. The work of legal scholars like yourselves further assists our analysis, particularly in the most difficult cases where we draw on academic work to really push our thinking. Although our powers to compel extend only to our borders, our powers to persuade extend nationwide. Working on such cases and having your analysis adopted by sister courts, Justice O'Brien, I'm hoping you're going to cite us regularly now. I'll be citing you afterwards, is probably one of the most satisfying parts of the job. This is true even when scholars such as yourselves strongly disagree with what we've written, which you regularly do. Now, I want to emphasize something. So Cass Sunstein said all judicial opinions are incompletely theorized, right? So, and I agree with him, particularly mine. But I want you all to engage in a thought experiment. Imagine if you had to get 6 of your colleagues who teach in the same area to agree with one of your articles. Think it's going to come out exactly the way you want it? A lot of compromise out there. Anyway, for me personally, perhaps the most interesting work I do relates to state constitutions. Here, the idea of second best is deeply ingrained in our constitutional law psyches. Most law schools, but not, as Dean Sharp has assured me this morning, do not teach state constitutional law. And for many advocates and scholars, the federal Constitution and the nationwide protection it guarantees is what matters. State constitutions are secondary concerns, at best backup protections or afterthoughts. This, I believe, is really deeply mistaken. When I was trying to convince students to take my state constitutional law class at Boston College Law School, and not something potentially more lucrative like the corporate litigation classes Professor Winship teaches here, I would emphasize to them if they want to be constitutional lawyers and wanted to do innovative, groundbreaking constitutional analysis, they should think about state government and state constitutions. As a member of the governor's legal office, I dealt with complicated separation of powers issues every day. The Attorney General's office does the same thing, at least certain divisions in the Attorney General's office, and I'm sure that's true here in Illinois as well. Assistant DAs and public defenders, if they're doing their jobs correctly, should also be state constitutional law experts, as they must understand and apply the double protection offered by state constitutions to the rights of criminal defendants. I also believe that some of the most creative constitutional research and analysis is being done regarding the interpretation of state constitutions. It's far easier to find unexplored territory and develop novel constitutional modes of analysis for state constitutions than for the federal Constitution, which is such well-plowed ground. This is also hard, time-consuming work. And again, for you law students out there or those thinking about clerking, this work is going to be done by you because it involves an enormous amount of research, takes a huge amount of time, and at least in the first instance, you're going to be doing that work, so you get the chance to do it. I also want to emphasize that there's just no more interesting time than right now for state constitutional law. And I think that's true for 3 reasons. The first relates to rapid changes and uncertainty in federal constitutional law proposed by the new 6-3 majority on the U.S. Supreme Court. The second relates to advocates shifting their focus to state constitutions and state courts because they think they have a better chance of success there. And the third, which I consider perhaps the most important, relates to more sophisticated understanding of state constitutional law that's described as the new judicial federalism, which isn't that new anymore for those of you teaching the area. The new judicial federalism is essentially when state courts interpret state constitutions independently and differently from how the U.S. Supreme Court interprets analogous provisions in the U.S. Constitution. This double protection of rights is, I believe, exactly what our federal constitutional system is designed to provide and what we're required to do as state judges when we interpret state constitutions and what state litigants must consider when they prepare their constitutional arguments. Indeed, it's my view, if state courts do not perform this non-deferential, independent review of state constitutional law and provide a double protection of rights, we are not fulfilling our duties as shared guardians of American constitutional rights. That's never been more important than right now. Court I sit on, and Justice Seifer used to sit on, has a long history of independently interpreting constitutions in certain contexts, having done so for close to a half-century. In these times, however, we no longer strain to justify independent interpretations, but rather recognize them as our right and responsibility and engage in such independent analysis with increasing frequency and regularity, focusing on the substance of our own state constitutional analysis and not on the justification for departing from the analysis of the U.S. Supreme Court for the federal Constitution. We're also doing it more often in response to the current U.S. Supreme Court's rapid reshaping of federal constitutional law. Retrenchment in particular, that is the reversal or cutting back on federal constitutional protections, has already prompted advocates to argue that analogous provisions in state constitutions protect such rights, even if the federal Constitution no longer does so. Dobbs, of course, is the most important recent example. In Massachusetts, we'd actually already interpreted our state constitution to protect the right to an abortion, so we were not affected by the Dobbs decision. With the new 6-3 majority of the court regularly reversing established precedents and something I would emphasize even more, issuing multiple concurring and dissenting decisions in a number of the most important cases, we're also confronted with more uncertain and unclear federal constitutional holdings. I do not envy those of you who are teaching federal constitutional law these days, trying to make sense of all of that. Rather than entering that thicket, we are increasingly turning first to our own state constitution, for if it protects that right, we need not resolve the federal questions. Our decisions then are also insulated from review by the U.S. Supreme Court because they are based on an adequate and independent state ground. As Justice Seifer will attest, my court does not do well if the U.S. Supreme Court takes one of our cases. We are scared to death of them. My big role in the court is trying to keep us away from them. So let me give you a recent example, which involves the enforcement of civility codes in Board of Selectmen. The plaintiff in this case, called Barron versus Coenda, had come to a public meeting of a municipal board of selectmen to complain about various actions of municipal officials, particularly violations of the open meeting law, which the town had undisputedly done. The AG had already enforced it, found them in violation. She also objects to overspending by the board, and when she does it, the chair of the board accuses her of slander and threatens to have her removed from the public meetings. This is a 75-year-old lady, on the grounds that she was violating the civility provisions that the town had enacted, which required, quote, all remarks and dialogue in public meetings must be respectful and courteous, free of rude, personal, or slanderous remarks. When she followed up and called him a Hitler, he ended the meeting. So advocates brought suit, claiming the civility code violated her state and federal constitutional rights and to free speech and also the right to petition under both the federal and state constitutions. Article 19 of our state constitution provides that people have a right in an orderly and peaceable manner to give instructions to their representatives and to petition them to redress the wrongs done them and of the grievances they suffer. When the case was removed to federal court by the town, the advocates dropped all of their federal claims. So they wanted to get back into state court. Again, at that point, they feel they have a better chance with us. And it comes back to us. So after parsing the text, history, and purpose of the provisions, including the writings of John Adams, who was the author of our state constitution, and the actions of his cousin, Sam Adams, who was a famous rabble-rouser and, for you students out there, beer maker, we conclude, as written, this provision expressly envisions a politically active and engaged, even aggrieved and angry populace. We therefore conclude that civility can be encouraged, but it cannot be required regarding the content of what may be said in a public comment session of a governmental meeting without violating the state constitutional right to petition. We wrote that our provision reflects the lessons and spirit of the American Revolution. It rose out of fierce opposition to governmental authority and was designed to protect such opposition, even if it was rude, personal and disrespectful to public figures, as the colonists eventually were to the Crown's representatives in Massachusetts. I, of course, wrote this decision, and my colleague said, "You've created the right to be rude," which they said was very appropriate that I had done that. Justice Cipher can comment on that later. Our interpretation of the state constitutional provision was not guided by the federal interpretation of the right to petition in the federal Constitution. Again, I will defer to my two experts here, but indeed that provision has not been given much attention or independent significance apart from the rest of the First Amendment. The First Amendment case law in public meetings is also, or at least it was at the time I wrote the decision, very unclear, with the circuit courts divided over the proper standard of review to apply to speech and what the federal courts referred to as limited or designated public forums. May have gotten clearer since then. You too will let me know. But by relying exclusively on state constitutional law, we avoided the federal confusion and insulated our decision from Supreme Court review. I strongly believe that such independent state constitutional interpretation enriches the American constitutional dialogue. It is definitely not second-best constitutional law. Our dual federal constitutional structure ensures that a single court does not have exclusive control of all American constitutional interpretation and the rights and liberties of all Americans. Instead, as Oregon Supreme Court Justice Hans Linde wrote, 50 different courts will talk with each other, as well as the federal courts, about the meaning of American constitutional rights, thereby testing and refining the interpretation of these rights. As has been demonstrated many times in the past, this type of comparative analysis improves constitutional analysis and has often resulted in rethinking by the U.S. Supreme Court. The Massachusetts Supreme Judicial Court's trailblazing decision in Goodrich, declaring the prohibition against gay marriage unconstitutional under the state constitution and setting the stage for the Supreme Court's decision in Obergefell, is a classic example of how courts can and do learn from each other. The last subject I'll talk about today is state autonomy, particularly the importance of state autonomy in a time of federal constitutional upheaval. The 10th Amendment expressly provides that, quote, "the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This express protection of state sovereignty serves an important purpose. As Madison famously wrote, in the compound Republic of America, the power surrendered by the people is divided between two distinct governments, and then the portion allotted to each subdivided among distinct and different departments. Hence, a double security arises to the rights of the people. The different governments will control each other, and at the same time, each will be controlled by itself." State sovereignty, especially again in this type of time of real fundamental federal constitutional change, and can no doubt, whatever your views are, we're in such a time, is critical as it provides the people with that double protection against the accumulation and abuse of power. It also allows the states to serve, in the words of Justice Brandeis, as the laboratories of democracy. It further ensures that the laws and regulations governing our daily lives are established by those closer and more accountable to the people being governed. Being face to face with those whose laws and regulations you're imposing is a source of great discipline. When I was in the governor's legal office drafting legislation and regulations, and at Massport permitting runways and new terminals, I was yelled at community meetings across the country. Literally from the Berkshires to Boston, not across the country, just across Massachusetts. It definitely has an effect on you. When you come back after getting talked to by the whole city of Worcester, As I explained earlier, independent state constitutional interpretation provides an important means of preserving state autonomy, and I believe is alive and well right now. Of course, when we're evaluating the state of state autonomy in current times, we cannot just consider the relationship of state courts and state constitutions to the federal courts and the federal constitution. We also have to consider the other two branches of the federal government, Congress and the president, and the effect of their actions on state autonomy. I believe that three specific limitations set out in the Supreme Court's case law should drive the analysis regarding congressional or presidential actions arguably restricting state autonomy. Those three limitations are: one, the requirement that any intrusion on the historic powers of the state be supported by a clear, unambiguous statement of congressional or constitutional authority; two, the prohibition against the commandeering of state officials by the federal government; and three, the rule that conditions imposed on the states to receive federal funding cannot be coercive. Although these three limitations have been developed mostly in the context of congressional intrusion on state autonomy, they should, I believe, be applied to presidential actions as well. The current administration's most recent executive orders raise questions regarding all three. I'll begin with the clear statement requirement. The Supreme Court has consistently emphasized, quote, if Congress intends to alter the constitutional balance between the states and the federal government, it must make its intentions to do so unmistakably clear in the language of the statute. More specifically, the court has held that Congress should make its intention clear and manifest if it intends to preempt the historic powers of the state. Ambiguity is simply not enough when changing the fundamental allocation of power between the federal and state sovereigns. The same principle, I believe, should be applied to the president, at least when the president's constitutional powers to faithfully execute the laws are involved. As the president's power to faithfully execute the law are obviously derivative of the laws passed by Congress, and since such laws cannot intrude on historic powers without clear authorization, the president's powers pursuant to such laws should be similarly limited. The Supreme Court has certainly limited the power of federal administrative agencies as executive actors to interfere with state powers, absent clear legislative authority on major policy questions. The decision last year or the year before limiting the power of the EPA under the Clean Air Act is perhaps the best example. How the court will interpret the president's independent constitutional powers in this context remains to be seen. Although the Supreme Court has adopted Justice Jackson's famous Youngstown concurrence, the court has increasingly stressed the importance of a vigorous unitary executive with wide-ranging authority. While Justice Jackson emphasized the dangers of preclusive and conclusive presidential powers, that is to say, executive power unsupported by or even contrary to express or implied legislative authority, the current Supreme Court seemed to emphasize the importance of such powers in the presidential immunity decision in Trump versus the United States last year, which raises a lot of questions about what they're going to do. Another critical bulwark against federal intrusion on state sovereignty is the Supreme Court's anti-commandeering jurisprudence. As to state legislatures, the court has explained that Congress cannot commandeer the legislative process of the states by directly compelling them to enact and enforce a federal regulatory program. Nor may the federal government, quote, dragoon into service the executive officers of the states. In the words of Justice Scalia, the powers of the federal government would be augmented immeasurably if it were able to impress into its service state executive and legislative officers. There's no reason to conclude that absent express constitutional authority, the commandeering of state officials by the president or the executive branch more generally would be constitutionally permissible when such commandeering by Congress would not. The same would be true of an attempt by the president or another executive actor to compel state legislatures to pass particular legislation. The anti-commandeering principle preserves the separation of legislative and executive power more generally. Congress cannot assume executive powers by commandeering state executive officials, and the president cannot assume legislative powers by commandeering state legislatures. The third protection of state autonomy I'd like to discuss appears in the court's spending clause jurisprudence. In addressing the constitutionality of the Affordable Care Act, the Supreme Court explained in great detail the relationship between the spending clause requirements and the design of federalism. Writing for the majority, Chief Justice Roberts observed that the court has, quote, repeatedly characterized spending clause legislation as much in the nature of a contract, which must be voluntarily accepted. Respecting this limitation is critical to ensuring that, in Chief Justice Roberts' words, spending clause legislation does not undermine the status of the states as independent sovereigns in our federal system. The court further recognized when pressure turns into compulsion, the legislation runs contrary to our system of federalism. Such compulsion was evident in the conditions imposed on Medicaid expansion by the Affordable Care Act, which several states argued went well beyond encouragement and amounted to coercion. The court agreed and characterized such financial inducement as the proverbial gun to the head, loaded with the threat of losing not merely a relatively small percentage of a state's existing Medicaid funding, but all of it. As you healthcare professors know, that funding amounts to nearly 30% of the state's budget. Spending conditions imposed by the executive branch, rather than by congressional legislation, as in the case of the executive orders that impose conditions on funding eligibility, raise additional constitutional concerns. When the executive takes such action, not only is the constitutional balance between the state and the federal government being altered, but the federal actor with the power of the purse is not the one imposing the condition. In these circumstances, it's not only the scope of the conditions that must be analyzed, but also the authority of the executive official to impose such conditions. Several courts have found that the president lacks the constitutional power, this was during his first term in particular, to cut off congressionally authorized spending in order to compel state and municipal officials to assist federal immigration efforts. In so doing, the courts have applied the framework established by Justice Jackson in Youngstown and focused on the absence of congressional authorization for the executive to discontinue funding. The Supreme Court, however, in ordering or denying interlocutory relief recently, has, however, been quite deferential to the president's authority to cut off funding, including previously authorized funding, at least when that funding directly relates to the program being executed. The court's recent grant of a stay in a couple of cases, the McMahon versus New York, the Department of Education case is a good example, suggests that the court may provide the president substantial discretion in this area. Nevertheless, until that case is decided, and also the NIH cases, ultimately on the merits, we're really not going to know what's going to happen yet. Today, many state AGs are contesting federal executive orders and actions that they contend upset the historic constitutional structure dividing power between the states and the federal government. The same was true during the previous administration, although the AGs and the president were on the opposite political parties. Without commenting on any specific case, and I cannot comment on that as a sitting judge, it is my belief that the general principle and practice of pushing back on the exercise of federal power by state AGs is fully consistent with the design of federalism and makes the work of state AGs particularly important, and why law students should really consider those jobs. Our dual constitutional structure ensures that the states and the federal government prevent overreaching by each other. Alexander Hamilton, writing in support of a dual sovereign structure in the Federalist Papers, explained, quote, "The general government will at all times stand ready to check the usurpations of the state governments, and these will have the same disposition towards the general government." In Hamilton's words, power is almost always the rival of power, and the states remain one of the few institutions in this country with the power to rival an ambitious federal executive branch. In so doing, they protect the very liberty of the people. Concerted action by the AGs is an especially important check. So far in 2025, state AGs have brought numerous cases challenging various executive orders. Perhaps most importantly, although the loss of federal funding undoubtedly places great pressure on them, the states are positioned very differently than private parties who may be driven out of business or into desperate financial straits by an order that remains in effect for months or even years before it's overturned. In the words of Justice Ketanji Brown Jackson, success takes time. The states, in my view, have the resilience and resources to continue to defend their autonomy. As someone who has devoted his professional career to state government and the benefits and protection it provides, I consider this a very good thing, and I hope all of you do too. I also hope that some of what I've said today resonates with each of you, and that you will give state government, state courts, state constitutions, and the importance of state autonomy a second look. This is my small bequest to you today. Whether this bequest, like Shakespeare's second bed, is truly second best, I leave to you. thank you for listening. It's been an honor to give this lecture, and if you have any questions, even Justice Cipher, I'm happy to answer them.
Thank you so much. So if anybody has questions, please raise your hand. I think that we have a microphone here for anybody who doesn't want to come up to the microphone, which would be preferable, but is not required.
Thanks so much for this. I wonder, I don't care much about the
So
common
you
law.
pointed, you're a federal constitutional law professor?
Yes, yes,
Okay,
yes.
all
No,
right.
but
Now
I,
I'm
no,
nervous.
but I spend a lot of time dealing with state constitutions
Okay.
as well. And I wanted to ask you, how independent do we really think state courts can be in interpreting provisions of the state constitution that have an analogous provision, a corresponding provision in the federal constitution? State judges, as you know, spend a lot of time applying federal law, and so they pay a lot of attention to what the U.S. Supreme Court says. It seems almost human nature that if you've absorbed all of that, when you turn to the same words in the state constitution, that you might be inclined to follow or at least be influenced by what the U.S. Supreme Court said. And your court, a couple of years ago, decided a case involving whether there was a state constitutional right to assisted suicide. And I was very interested in the decision because before you get to whether there is such a right under the state constitution, you have to decide what is the methodology for discerning whether there are such rights. And your court, it's not your opinion, but your court
I
says...
was my wife's firm represented one of the parties. I was
got it.
accused.
Right, so I could be more aggressive. The court says, well, there's the Glucksberg approach, which is a kind of narrow approach, or there's the Obergefell approach, which is a sort of more capacious approach, ends up settling on the Obergefell approach. But when I read that, I thought, consistent with everything you just said, well, isn't there a third approach, which would be a state-specific approach? How do you go about making sure that you're not unduly influenced by all that federal law?
Yeah, and I think it's a great question because, it's so much easier to follow. There's so much more federal law, particularly on undeveloped, when you're dealing with a state constitutional provision for the first time, almost always there's going to be a lot of federal constitutional law on something. So your natural tendency is to turn to federal constitutional law. There's been, again, a tremendous amount of scholarship goes into those federal constitutional opinions. So again, your tendency is to turn to that. I think now and the alternative is a lot of hard work, a lot of digging. You're off on your own. Unlike my colleagues who are elected, and they can say, they have the advantage of saying, I couldn't do this because of the feds. That's also a concern. You're exposed when you start doing this constitutional analysis as opposed to just deferring to the feds. But I think the more uncomfortable justices are becoming with originalism as it's being developed, that hesitancy is going away. At least, but again, it depends on the court. But at least on the courts I'm most familiar with, we're going our own way more often, even if it's difficult. But it requires a lot of work. I mean, that Barron versus Calenda, someone else was writing an opinion using the federal stuff, and it was so complicated. I went off on my own and wrote what ended up being our opinion, and everyone joined it. And I might have gone your third way in that euthanasia case. I wasn't on the panel, but yeah, it's a good question why we didn't necessarily explore the third one, but sorry.
Ralph.
So, on the same theme, when you're trying to take an independent approach, what's your methodological baseline, especially as compared to what the Supreme Court does, which is heavily originalist now? Are you also originalist? How much variation is there in terms of independent approaches during the state constitution?
Yes, another great question. So I'll give you a recent example. I just wrote an opinion relatively recently involving the excessive fines provision under our state constitution. we hadn't interpreted before. That basically it was clear the plaintiffs were going to lose under the excessive fines under the feds. So they made just a pure state constitutional law argument on it. And again, I think you can't do state constitutional analysis, particularly the first opinion you're writing, without doing that kind of originalist analysis. You've got to dig deep. You've got to try to understand what the basis was. So there's an originalist element to it. But I got a lot of pushback from my colleagues saying, we're not pure originalists. Be careful here about how much you're going into originalism. We don't. And then I also had a debate. I was on a panel with Chief Judge Sutton, who's he's the mountain of state constitutional law. The rest of us are molehills. And he's very much an originalist. And I go, well, once we've written our first decision, we do common law constitutional analysis here. We're not purely gonna, we're doing what David Strauss at Chicago, that common law constitutional thinking. We're not, stuck in this kind of originalist, rigid originalism. But again, I think you need to start there because otherwise you're not going to be able to derive the principle that we're doing. But we're trying to develop our own approach. But I was surprised by because my draft read much more than I was aware of as like an originalist approach. Because again, you can't start. You got to start there. But my colleagues were vigorous. I think they improved the opinion a lot. It's a case involving. We had any of you have ridden in Mass. We had police officers on our turnpike making up overtime, writing fake tickets, so the guy made about $75,000 of unwarranted overtime, and then he lost his $1 million pension, and he said it was an excessive fine. And the other reason we split from the U.S. Supreme Court is the Supreme Court hasn't addressed the issue of whether a fine that makes you destitute is excessive. And we have a footnote sort of addressing that, but another great question. Sorry. Mm-hmm. Oh, you're good. You can't hear.
And Leslie, make sure to turn the mic on.
Can you hear me? Oh, perfect. So I was going to ask about Lanier versus Harvard. I read your opinion. I read the concurrences as well. And I think, all of the judges had some unease with the fact that, whether the issue could be left to the legislature to decide. And I was hoping you could talk a little bit more about why you were reluctant to use the court's equitable power in this instance, and probably tell the audience more about the case.
Did she make you do this?
I have actually written a tiny bit about this myself, so
I think
it's
I've
only from me.
I think I've seen what you've written. So very thoughtful. So again, I'm probably telling tales a little out of school, which I got to be careful. So the opinion starts out focused on there's only a negligent infliction of emotional distress left, which leaves us really unsatisfied. The case, for those of you who haven't read it, it's an awful case. I'm going to mispronounce his name, Agassiz, I think his name is. He's a famous Harvard, and he had this sort of racist theory that and he could prove so he took pictures of slaves, and he had the woman half daguerreotypes. They're daguerreotypes where the woman is half naked, the man is almost fully naked. They're really troubling photos. Now, this is on early stages. We don't have a trial here, so we don't have full facts. We're not sure these people are actually the descendants of these people. That's the allegation. There are all kinds of First Amendment issues because Harvard is using these daguerreotypes, including Gates, for education on slavery, but they're doing it in a kind of way where they're not fully fessing up to how awful this professor's behavior was in 1860, in the 1860s. Because again, it's legal at the time. Slavery is legal at this time, so it's very complicated. And so I write an opinion which finds there's an intentional infliction of emotional distress possibility here, because Harvard's grossly insensitive to how it's presenting these materials. But we're also very concerned. We got First Amendment issues. Justice Cipher will speak for herself on how I think she created a new common law right rather than something that should have been done by statute, but you may side with her. So I went as far as I was comfortable with the law. And again, I'll let Justice Cipher kick in. But the other thing that influenced me was we're not like you. We're pragmatists. We felt our decision was going to put a huge amount of pressure on Harvard, and it actually did. It resulted in the right thing. These daguerreotypes are going to a museum. They're not going to be, but again, we could not find any common law support for that. If someone's picture has been taken, they own the picture. There are all kinds of problems with that from a First Amendment perspective and other things. But I will turn it over to my colleague for my next battering. She's, by the way, my closest friend on the court. We've been together in 2 different courts, and she picks on me nonstop.
And what we said about Justice Kafker all the time is that if he could find a principle, he could narrow it until it was almost invisible.
That was when we were both on the Intermediate Court of Appeals trying to avoid being reversed.
But so I'm glad that survived. In retrospect, I wish I hadn't created the court. In opinion, that was to try to get one of you. I should have taken that right out and just said the history of the SJC, which did a lot of things during slavery to do things right, sent this man, Massachusetts man, down to do something terrible. This is not, and because terrible because of the depiction, but also how long it would take a person to stand or sit for the daguerreotype. It is a one-time, it is pre-photography, so you can't call it a photo. You can't call it a picture. You've got to call it a daguerreotype and take it as an object. And I believe that Tanya Lanier proved her lineage sufficiently for the case. It was just a motion to dismiss, so summary judgment, whichever one it was. It wasn't a full trial yet. She would still have to go through those phases. So I thought we should, as the Massachusetts court that did so much on the slave cases and on declaring slavery illegal and unconstitutional, that we should make that one more step using our own equitable power, which we never used, and our own common law power, and say this is so wrong that it should belong to her.
Yeah, I was very worried about the First Amendment problems associated with this. And, well, you have, basically, these pictures have historic value. These daguerreotypes have historic value. They were being used by probably the premier historian, Henry Louis Gates, for presentations Harvard was doing. And that's at one of those presentations, they really upset Lanier because they didn't acknowledge. They said went on to become famous. He was famous for zoology, not for this. And then they insensitively described Renti as being invisible. And so they mishandled this thing. And also, they were pushing Drew Faust to meet with them. Again, I felt like there were easy claims that on emotional distress, but even those were going to be narrowed by the First Amendment. What caused emotional distress? Does that conference on slavery where they put those daguerreotypes, is that going to be able to be used as emotional distress? I don't think so. Oh no, I understand. But it's a great case. Sided with Justice Cipher.
I'd love to teach a course on that book, use that book as just use the book, you can teach a whole range of things.
You better invite me. Better invite me to give my point of view.
We could do a whole course around it.
Other questions?
Other questions?
I knew I wasn't going to get out of here alive.
You opened yourself up.
Justice Kafker, thank you. This was amazing.
Thank you very much. Thank you.
We have a small token of our appreciation and gratitude.
Oh, thank you very
Chico.
much. Oh, excellent. I need a pen.
Yes, that's right. There's a reception in the pavilion. I ask that you join us and converse with Justice Kafker and Justice Cipher if you want
And Justice O'Brien.
and Justice
Judge-
O'Brien. Well, if you want Justice Walker, Justice O'Brien too. I'm not. He wants to rope you in. I'm just saying that it's an open invitation if you would like. But refreshments in the pavilion. Thank you all for attending. Thank you very much.
Thank you.
This was
Great. No, good. I'm glad you like that.
Yeah.
I wish more kids would show up because there's a lot of
I
them
know.
directly his
Is that them? Yeah. I mean, I know. It's like
Especially because I feel like people like you and me and you want to do public service. That government's scary.
that's I know.
But anyway, no, that's good. I love that. That's from the faculty.
Interestingly, right to that point, I remember I was mentioning to Justice O'Brien how our graduate is doing. This was a student, I think that she was like maybe number 5 in her class last year. She had